I think I had partly covered this subject in some previous program, but on that day, due to certain unavoidable reasons, it could not be completed. Therefore, today I will restart and will cover this entire subject afresh. Those who could not participate in the program earlier on this subject, they have the opportunity today to listen me and to put their queries, to seek clarifications to their doubts with regard to the subject under our discussion today. So as you people are already aware, we are going to cover and discuss in this session a unique subject which relates to scientific evidences. You know, scientific evidences are produced out of scientific tests. With the advancement in science and technology and with the passage of a new legislation which we know as Information Technology Act 2000, and with the insertion of new provisions in the Code of Criminal Procedure, that CRPC, outgone CRPC 1973, and now this BNSS 2023, Bharatiya Nagrik Suraksha Samhita 2023, which has been implemented from July 1st, 2024. Lot many provisions have undergone changes, amendments. Many new provisions have been added in this BNSS in Sakshya Adhiniyam, Bharatiya Sakshya Adhiniyam 2023. Earlier in Indian Evidence Act 1872, many of the provisions which have now been added in this Bharatiya Sakshya Adhiniyam 2023 were already there by way of amendment of the Indian Evidence Act in the year 2000. As I pointed out earlier, the Parliament had passed a new legislation, Information Technology Act 2000. As a result of this new legislation brought by the Parliament in 2000, the same Parliament thought it proper to insert many provisions in the Evidence Act of 1872 as well, in order to assimilate into the evidence laws the electronic evidences. Many sections in the form of capital A, 67A, 85A, 88A, and similar other new sections in the Evidence Act came to be added in the year 2000. Then in the year 2006, CRPC underwent fresh changes, fresh amendments, and certain new sections were added in the form of Section 53A, Section 164A, Section 311A in the CRPC to incorporate in the CRPC the results produced by scientific tests like D.N.A. report, like results of examination of blood either of the victim of the offense or that of the accused, to obtain signature, to obtain voice as sample from the accused and send it to the forensic laboratory for matching with the voice of the accused that was recorded by the agencies or by some other person when the accused was in the process of commission of the crime under investigation or under trial. So taking signature, specimen signature, taking specimen voice, taking specimen writing of the accused for purposes of detection of crimes and criminals was the object behind introducing Section 311A in the CRPC in the year 2006. In the same year 2006, Sections 53A, 164A were also added in the CRPC. Section 53A intended to subject the accused who has been alleged to have committed sexual offense to D.N.A. test. Section 164 empowered the investigating officer to take the victim of the rape to the nearest government medical practitioner to obtain sample from her body like hair, like blood, like any other substance from her body and send it to the forensic laboratory for conducting D.N.A. test. So these scientific tests were introduced in the CRPC, in the Evidence Act, to ensure that all possible evidence is brought by the investigating agency before the courts during the course of trial, appeal, or other proceedings before the superior courts. The purpose was to enable the courts to reach justice, to do justice. If the accused had really committed the crime, then to ensure that the accused does not go scot-free, he is punished. So such scientific evidences were thought to be quite helpful in criminal justice system of our country. And that was the reason that the parliament thought it proper to amend the CRPC, the Evidence Act, by introducing these new provisions which I just referred to and again repeated. Section 53A, Section 164A, Section 311A in the Evidence Act. Similarly, many sections in the Evidence Act of 1872, some of them being Section 65A, 67A, then 85A, 88A, and onward. The purpose was to ensure that material pieces of evidence with the help of technology, scientific knowledge be brought on record in order to enable the courts to do justice, either to hold the accused guilty or if he is not guilty, he was not otherwise involved in the commission of the offense, to set him free. So in brief, this has been the object behind amending the then existing laws and introducing the new provisions in the form of the new sections in the CRPC and in the Evidence Act. For purposes of this today, I would like to draw your attention to my website, lawhelpline.in. Those who are participating for the first time today in this session, they may note down this website in small letters without space. It is lawhelpline.in. LAWHELP, lawhelpline, LINE, lawhelpline.in. In small letters without space, the site is lawhelpline.in. It contains many articles, writes up on different subjects of laws. One of them is this subject, which is under our discussion today: DNA, narco analysis, polygraph tests, etc. It is available on this website, lawhelpline.in. It contains all the relevant leading decisions of the Supreme Court of India and of different high courts, which shed light, which add clarity to the evidentiary value of the results, reports produced by different types of scientific tests. What is the evidentiary value of a report prepared by the experts in the forensic laboratory? How should the courts in India deal with such reports of the scientists, experts who had conducted the particular scientific test and had prepared their reports, their results? All these things have time and again been dealt with by the Supreme Court, by different high courts. So the value of result of scientific tests will be discussed today by us with the help of leading decisions, rulings of the Supreme Court and of different high courts. So those who have opened this website of mine, lawhelpline.in, I request them to come to point number 1.1, para 1.1 of the article named DNA, narco analysis, polygraph tests, etc. At para 1.1, I'm drawing your attention to different types of scientific tests which are generally applied by the investigating agencies during the course of investigation of crimes. The scientific tests which are generally applied by the agency, they are DNA test, RNA, ribonucleic acid, DNA, RNA, lie-detector test, polygraph test, brain mapping test, narco analysis test, voice analysis test, fingerprint test, handwriting test. So these are certain scientific tests which have been evolved by the technocrats, by the scientists, and by the experts on different tests which we just enumerated. We shall take up these tests one by one. The result produced by these tests are ultimately to be brought before the courts, and then courts should be called upon to examine the evidentiary value of such test reports. For whom these test reports are prepared? Firstly, for the investigating agency in order to submit the charge sheet against the accused, or if the test report has gone in favor of the accused, then to submit final report in his case if he is not found to be otherwise involved. Broadly speaking, there are two users of the test reports of the scientific tests. First one is the police, the investigating agency who investigates the offenses, and second, the courts, which uses the scientific evidence report of the scientific test submitted by the investigating agency as piece of evidence. The police and courts, they use it to come their logical and just conclusion. I'm again enumerating the test: DNA, RNA, lie detector, polygraph, brain mapping, narco analysis, voice analysis, fingerprint, handwriting. These are certain tests. I'm inviting your attention to clause 3 of Article 20 of the Constitution of India. Those who have gone through the Constitution, this Article 20 appears in Part 3rd of the Constitution of India. And you know, Part 3rd of the Constitution is devoted to fundamental rights. So this Article 20 and its Clause 3, they are related to fundamental rights of a person who has been accused of having committed some crime. So this Article 20 Clause 3 provides that an accused person shall not be compelled to be witness against himself. You know, in our criminal justice system, in our criminal jurisprudence, the burden to prove its case beyond all reasonable doubts lies upon prosecution. An accused is treated to be innocent during the course of arrest, detention, remand, either in judicial or police custody, during the course of moving of his bail application, and even when his bail application is rejected by the court, even then he is treated to be innocent. During the inquiry, during the entire course of trial of his case, the accused is treated to be innocent, because our criminal jurisprudence mandates that unless proven guilty, an accused person has to be treated to be innocent. It is a fundamental right. Article 21 of the Constitution, what does it say? It says, no person shall be deprived of his life or personal liberty except in accordance with the procedure established by law. So when after due trial, completion of trial, the accused is ultimately found to be guilty in the judgment passed by the court, only then his fundamental right to be treated as innocent is gone. Otherwise, right from the stage of registration of FIR till pronouncement of judgment by the trial court, the accused has to be treated to be. I'm again reminding you, just because a person has been arrested in connection with some crime, it doesn't mean he has been arrested and his right of being treated as innocent has come to an end. No, arrest is altogether a different thing. It's a part of investigation. Arrest is part of investigation. And so long as the matter is under investigation of the agency, of the investigating officer, the person has to be treated to be innocent. Same is the position before the courts. Unless the court finally pronounces its judgment holding the accused to be guilty, before that stage, at every stage of the proceeding in the court, the person has to be treated, the accused has to be treated to be innocent. So the same is the position here. This Article 20, Clause 3 says, a person accused of an offense cannot be compelled to stand as witness against himself. Why I am referring this Article 20, Clause 3 to you? The reason is that if an accused is subjected to a scientific test in order to obtain a report gather a report, scientific test report, which may ultimately be used against him either by the investigating agency or thereafter by the court. So then this report will be read against the accused. And this Article 20, Clause 3 mandates, an accused cannot be compelled to be a witness against himself. Accused person cannot be compelled by court, cannot be directed by the agency or by the court to give evidence against himself. Then how does it happen? When an accused who is alleged to have committed rape against a lady is taken to the nearest medical practitioner of the government for subjecting him to DNA test, Section 53A CRPC, which is now in BNSS 2023, Section 52. You know the places of the sections in the CRPC have now changed in the BNSS, Bharatiya Sakshya Adhiniyam. Everybody is by now perhaps familiar. Our procedural code has been replaced by this BNSS insert. Earlier it was called and known as CRPC 1973. Now it is known as BNSS 2023. Full name is Bharatiya Sakshya Adhiniyam 2023. So is the Indian Penal Code of 1860. It is now Bharatiya Nyaya Samhita 2023. Indian Evidence Act 1872 is now Bharatiya Sakshya Adhiniyam 2023. So these new pieces of legislation are now with these names in application, in use from July 1, 2024. You people are well familiar with this new law, criminal law, which has come into operation from July 1, 2024. Again, referring to Article 20, Clause 3, no person can be compelled to give any specimen, any substance from his body for purposes of conducting any scientific test if he is an accused in that case. But there are exceptions. Despite the bar of Article 20, Clause 3 in the Constitution, the Parliament inserted in the year 2006 in the CRPC, Section 53A, empowering the investigating officer to take the accused of rape to the medical practitioner of government for subjecting him to DNA test, to take sample from his body so that DNA test may be conducted. The Parliament added 164A. Again, this bar was ignored, Article 20, Clause 3. But the only rider in relation to the victim of rape, victim of sexual offense in Section 164A, which is now 184 in your BNSS 84 or BNSS 2023. It is now Section 184. It says, unless the victim of the offense of rape gives her consent to the investigating agency, investigating officer, she cannot be taken to the medical practitioner of government to give any substance from her body or conducting DNA test. If she gives her consent, then all right, DNA test can be conducted, sample can be taken from her body, hair, blood, or anything whatever that medical practitioner thinks proper. He can take it from the body of the biological substance, what is called biological substance. So this is the law. For purposes of DNA, the Parliament has inserted Section 53A, 164A, which are now in the BNSS in the form of Sections 52 and 184. Under these two sections, the IO has power, subject to the consent of the victim of the sexual offense, to take her to the nearest government medical practitioner, the sample for conducting DNA test. Section 53 empowers taking sample from the body of accused who is alleged to have committed rape. Section 164A from the body of the victim of the sexual offense. So these are two important sections. Then there is another section 311A. It is perhaps 349 in BNSS now. You can see it from the table given in the beginning of the BNSS. What is the new section for the outgone section of the CRPC? So section 349 of the BNSS empowers the magistrate to permit the investigating agency to take signature, specimen writing, or specimen voice for purpose of investigation. And whose signature, whose writing, whose voice can be taken? That of the accused, against whom the investigation is being conducted. The only rider is the accused must have been arrested during the course of the investigation. So this is the position of law. So these three sections are in fact exceptions to this Article 20, Clause 3 of the Constitution. This Clause 3 of Article 20 bars other scientific tests, but not the DNA test, not the taking of signature as sample, taking of handwriting of the accused as sample, taking of voice of the accused as sample, as a specimen. So this is these three sections, 53A, 164A, and 311 of the outgone CRPC. Now in the BNSS, they are 52, 184, 349. They are exceptions to Article 20 and its Clause 3. There has been a very leading case in the Supreme Court in the year 2010, Srimati Selvi versus State of Karnataka. That judgment was by a three-judge bench. In that case, Supreme Court had already ruled, even before this BNSS 2023 came into force in the year 2010, that DNA test could have been conducted, but other tests like polygraph test, lie detector test, brain mapping test, narcoanalysis test, they could have been conducted only with the consent of the accused. Why? Because of bar of Article 20, Clause 3. But in relation to DNA, this bar was not applicable. The reason being, in the year 2010, in the year 2006, Parliament had already inserted Section 53A and 164A, empowering the investigating officer to take the accused to the medical practitioner for taking specimen samples from his body, or the victim of the offense of rape for taking sample by the medical practitioner. So since Parliament had made that provision, and then in the year 2010, Srimati Selvi's case came, the Supreme Court rightly ruled that agencies had power, investigating agencies had power, and the court had power to direct such tests. So DNA was permissible. DNA is permissible even today, but other tests can be conducted on the accused only with the consent, not without his consent. So I'll refer here to you this important case. You must read Srimati Selvi, State of Karnataka, year 2010, Supreme Court, 1974, 3 judges. It's available on my website on this under this writer, DNA analysis. It's available here. You can go through it. Then inviting your attention to narcoanalysis test, polygraph test, and those tests other than DNA. They are not permissible given the bar of Article 20, Clause 3. If the accused consents that such tests can be conducted on him, only then investigating agency would venture to take him to the medical practitioner or to the expert for conducting these tests. Otherwise, tests like lie detector test, polygraph test, narcoanalysis test, brain mapping test, they cannot be conducted given the bar of Article 20, Clause 3. Supreme Court, in the same very case, Srimati Selvi case, had in the year 2010 ruled it. This position of law has been retained by the Parliament even in the BNSS 2023. So with the consent of the accused, any test can be conducted. But if he doesn't consent, does not give his consent, he objects, then except DNA, no other test can be conducted on him. I think this basic background of these scientific tests has by now been explained by me to you. Before proceeding further to what is DNA, what is the value of its report, evidentiary value in the scrutiny of the court, I would like you people to your queries with regard to these scientific tests, which tests are permissible and which are not permissible. If you have any question, please put. Otherwise, I will proceed further and take up next points.
What was the process if a rape victim is taken to a private hospital and not a government hospital?
Normally, in all districts, in all talukas, government hospitals, PSCs, CSCs, primary health center, they are known by different names in different states. But government controlled and government run hospitals and doctors are available everywhere. It normally doesn't happen, but still, Parliament has made the provision in 150, Section 53A, Section 164A, which are now in the new BNSS 2023 in the form of Section 52, Section 184, that in case under any compelling conditions, if a government medical practitioner is not available and the IO still feels that the DNA test has to be conducted, specimen sample has to be taken from the person of the accused or from the person of the victim of the rape, he can contact some private medical practitioner as well. But he will have to record the reason why he went to a private medical practitioner. If a government medical practitioner was available, then he cannot approach, cannot contact a private medical officer for taking the sample for these tests. So it is for the IO to record in his proceedings, in his diary, general diary, if medical practitioner is available, medical practitioner of the government is available, then the IO has no power, no option, no discretion, no choice, except to go to that government medical practitioner for taking specimen sample from the person of either the accused or the victim. It is only when the government medical practitioners are not available and IO venture to contact a private medical, and he will have to record this fact into his case diary so that this claim made by the IO, recorded by him in the case diary, be tested by the courts when the matter comes before the court for their scrutiny. So normally, an IO will have to contact only the government medical practitioner. In some rare case, a government medical practitioner is not available there and only a private medical practitioner is available. Of course, even sample can be collected by private medical practitioner. IO can take the victim or the accused to him and he will have to record this fact into his case diary. With this rider, with this precondition, even a private medical practitioner can be contacted. Any other question or should proceed further?
What is the best evidence from a scientific test according to you?
Scientific test, out of many tests, the only admissible scientific test report is DNA. The test, I will cover these points.
Okay, sir. So next question, what if the accused refuses for polygraphy or DNA test?
He will have to give his consent. Without his consent, given the bar of Article 20, Clause 3, and given that three judgment of the Supreme Court in Srimati Selvi versus State of Karnataka 2000 Supreme Court. If the accused has not volunteered polygraph test, lie detector test, the narco analysis, such tests can be applied to him. It's another matter. Many a times police records into its papers the consent, whether that consent is genuine or not. It is subject to scrutiny by the courts when the matter comes before them. In recent times, in some cases, particularly in Calcutta rape case, the police, the CBI had taken the accused doctor for conducting polygraph test on him, lie detector test on him. So I think during the period of custody of the CBI, the accused had given his consent to the CBI. Yes, I am ready. I have no objection. If the lie detector test or narco analysis test is conducted on me, and if there is no such consent, so such test cannot be conducted. But DNA can be conducted despite objection of the accused. Why it is so? Because law permits it. Section 53A specifically says for DNA. 164A says for DNA. Now these two sections are in the form of section 52 and 184 in the BNAS. Yes, the provisions are the same. All the provisions are the same, even in new sections in BNSS. So DNA can be conducted without consent, but other tests can be conducted on accused only with his consent, right?
Which register is DNA test registered in the police station?
In different states, the basic law is Police Act 1861. It is a British era legislation which exists even today in India for all the states, for all over. But states have made their own police manuals, police regulations. Such things are then regulated. Functioning of the police is regulated by the police manuals, police regulations, and different states have made their own police regulations, police manuals, keeping in view their needs of their local needs. The Uttar Pradesh is having a particular police manual, police regulation. Quite possible that the state of Maharashtra might be having some different provisions in the Maharashtra police regulation, Maharashtra police manual. Same is the position in respect to other. To keeping in view their needs, local needs, the states have made their own rules, regulations for regulation of such things. If you want to see for your state, you can see the police manual, the police regulation made by the state government of Maharashtra. In which register the police records its view in Uttar Pradesh, it is called case diary. You can, in simple language, say it police diary, general diary. You know all the proceedings which during the course of an investigation or even before start of investigation, when a person comes to the police station for getting his FIR registered, a brief entry is made in a diary that is in Uttar Pradesh in police manual called General Diary GD. In short, it is called GD. Roz Namcha in Hindi. Dainandini. So these are the words in Urdu, Persian, and Hindi in Uttar Pradesh. Your state might be using some different name, General Diary. It may be Daily Diary, DD. So nomenclature of such document is different from state to state because different states have made their own police regulation, their own rules regulating the functioning of the police, and they have given particular names to these documents. So there is no all India uniformity in relation to the names of these documents because these names are found in the police regulations, police manuals made by respective states. The CRPC, just see FIR. FIR word occurs in CRPC. In BNSS, it has been made by Parliament, not by any state government. Therefore, it uniformly applies to all India. Word FIR is used in all the states. Police report occurring in section 173(2) CRPC, for which there is a new section now in the BNSS. Police report, that means final report or charge sheet. These are the words which have been used by the Parliament, not charge sheet, not police final report, but police report word has been used. 173(2) police report, which means either final report, either charge sheet submitted by the investigating agency after completion of the investigation. So when a name, a nomenclature, a word has been coined by the Parliament, it will apply uniformly to all over India, to all states. But when a local law is made by a state and a state gives a particular name to a particular document, then only that name given by the state government would be used in that. I think this has now become clear to you.
Yes, sir. We are done with the queries.
Any more query or should take up other points?
Sir, please take up other part.
I'm inviting your attention to para 2.4.1. 241. Right. DNA narco analysis scientific test. Again, repeating this write-up is available on my website, lawhelpline.in. DNA and other tests. I am now taking para 2.4.1. Proof of identity of dead body by DNA is permissible. Suppose a dead body has been found by the police, but the identity of the deceased is not known. What's his name? What's his parentage? What was his place of residence or business? Who is he? Nothing is known about him. Only a dead body of a human being is recovered. The Supreme Court ruled in 2023, John Anthony versus State, 2023, Volume 3, Supreme Court Cases, page 536, 536. It is here at point number, para number 241 of my right. Proof of identity. The Supreme Court says identity of the dead body of a deceased person can be proved by the superimposition test and DNA examination of the limb of the dead body. You know, this is a field of expertise. Only a doctor, a person, an expert who has been duly trained in conducting the DNA test, he can conduct such tests. He can prepare the report based upon the findings of his test. So when an expert of DNA test applies these methods, what the Supreme Court has said, superimposition test and DNA examination test. So if the DNA conducting expert says that this dead body is of a particular person, so his report has to be accepted. How can it be made possible? Suppose a dead body has been recovered, a part of his body may be taken as sample, specimen, and his parents are there, children are there. This biological substance from the person of any of his blood relations may be taken, and both can be sent to the forensic laboratory for being matched scientifically by applying the test of superimposition and DNA. And if the result comes after the test that the both the samples meet each other, DNA profile meets each other, then his identity would be established. The deceased was the son or near or dear biological relative of such and such persons. So dead body, or even if dead body is not there, even a small piece of hair is found, then it can also be identified with the family, blood relatives to whom the deceased was connected, related. To a very small piece of limb part of the person of any person, the blood, sputum, skin, hair, bone, anything can be used for purposes of conducting the DNA test. It is must compared in accordance with the scientific method which is applied for conducting the DNA test. But there should be two sources. One, the biological substance are part of the body of other person and this accused. Not necessarily there must always be some person who is accused in offense. Suppose many people died in some flood, their dead body was recovered after months, bodies have decomposed, only bones are there. It will be difficult to establish whose bone is this and whose bone is that. So then nears and dears who claim their nears and dears had been washed away in the flood, biological substance from the living person should be taken and this bone would be sent to the laboratory. It will be matched with the, if it matches with the particular, if the bone, if the DNA findings of the bone, particular bone, matches with the particular biological substance taken from a particular person, then identity of the deceased would be established. Yes, this bone belongs to the near and dear of such and such person. So this is a scientific method. This is the boon of Vardhan. This is the boon of technology, scientific knowledge which the humanity has so far evolved. These are the methods, and that you can find this interesting thing in the case of John Anthony Sami versus State, 2023, Volume 3, Supreme Court Cases 536. It is available at para 2/1 of my right upon DNA. Supreme Court has again in this case ruled another case, Rahul versus State of Delhi, 2023, 1 SCC 83, 2023, Volume 1, Supreme Court cases at page 83. This judgment is by a bench of 3 judges, Rahul versus State of Delhi, 2023. DNA evidence is like any other expert opinion under Section 45 of Evidence Act, and its probability value may vary from case to case. The latest larger bench decision of the Supreme Court, 2023, by 3-judge bench, Supreme Court says it's not always necessary that the result produced after the DNA test may be treated by the courts to be binding or conclusive. No. Section 45 of the Evidence Act 1872. You must have read it. Section 45 of the Outgone Evidence Act deals with the experts. Who is said to be an expert? Who has some special knowledge, skill, study, expertise in any particular branch. Suppose the DNA test, somebody claims to be an expert on conducting DNA tests. He is an expert. Somebody claims to be handwriting expert, thumb impression expert, voice analyst. I had given a long list of different types of scientific tests. Every scientific test does have an expert who is expert in a particular scientific branch. He has to be treated to be expert on that subject. So within the meaning of Section 45 of the Evidence Act, a person who is skilled in a particular branch has a special skill, he can be treated to be. The Supreme Court says in 2023 in Rahul's case, these DNA experts are also like other experts under Section 45 of the Evidence Act, irrespective of the branch of knowledge, area of skill, area of expertise. The expert falls within Section 45 of the Evidence Act, for which there is a new section in your Bharatiya Sakshya Adhiniyam. The only precondition for a person to be treated as expert is that he must have special knowledge, special skill, expertise in some particular branch of science or technology, medical field, or any other field. The Supreme Court says that what value should be attached to the report, to the findings, to the opinion of an expert under Section 45 of the Evidence Act. Supreme Court rules that it will depend upon case to case. One expert may be relied on in one case, depending upon the facts and other evidence brought on record in that case. But the same expert may be disbelieved, discredited. Court may refuse to trust him in some other case on the basis of facts of those case, that case, on the basis of evidence, other evidence brought on record in that case. It doesn't mean that an expert has once been relied on by the court in one case, he will always be relied on by the court in all other cases. No, each case is decided on the basis of evidence produced in that case only. In another case, there might be some different evidence, facts might differ, evidence might differ. So it is for the court to apply its mind rationally, logically, and then come to the conclusion in the light of all other evidence on record, whether the opinion of the expert has to be accepted partly, fully, or to be rejected partly or fully. You know, this is the basic judicial function of a judge of court, to see that the case before it is decided on the basis of the facts before it, in that case, on the basis of the evidence before it produced in that case. So an expert's opinion is generally never conclusive. It is never final. Majority of the rulings of the Supreme Court say if the opinion, if other credible evidence, reliable evidence brought on record leads the court to the same conclusion which the expert is saying, then of course expert's opinion should be accepted. But if the credible evidence on record of the case leads the court to a different finding, different conclusion, and the expert is saying something different, then the expert's opinion has to be rejected. An expert's opinion can only be accepted when it finds support from other reliable evidence brought before the court. In that case, it is always safer, prudent, advisable to know, to make up one's mind like this. An expert and his opinion is never conclusive. Opinion report given by an expert is not binding upon court. It is always in the form of a suggestion. Report of an expert is always of advisory character. It has to be acted upon, it has to be accepted, relied on only when it finds support from other reliable evidence led by the parties. In isolation, it is never safe for the court to base its findings merely on the basis of opinion of an expert, irrespective of the category of the expert. Here, this D.N.A. category of expert, they are given the highest importance. If there is a handwriting expert report, it's a very, very big piece of evidence. But if it is a D.N.A. expert's report, it's a very, very important, valuable report. Normally, the test report produced by D.N.A. test should be accepted unless there are compelling reasons not to rely on it. It's not binding. A D.N.A. test report is also not binding upon court. But in comparison to other tests like handwriting, thumb impression, voice analysis, this is given the highest value, highest importance. But still it is not binding. Court can reject it if there are justifiable reasons. There is other evidence on record which dispels this reliability theory, then D.N.A. report can also be rejected. This is what the Supreme Court has ruled in this case. Rahul versus State of Delhi, 2023, one Supreme Court cases, page 83 judgments, paras 36, 37. So those who are interested in properly understanding this typical subject, scientific subject properly, and the role of the courts in properly analyzing the evidence relating to D.N.A. test, I would request them to read a few latest cases of the Supreme Court. Rahul, State of Delhi, 2023. Earlier, John Anthony Swamy versus State, 2023, Supreme Court. So these two cases are quite important for you. You can also add one more case, Ashok Kumar versus Raj Gupta, 2022, one Supreme Court cases, page 20. All these cases are given by me on my website under this subject. You need not to launch any other search, you can find it here itself. But I have briefly given what the Supreme Court has opined, ruled. For the full text of these judgments, you can download it. It's available on SEC online or in different journals. These cases are reported. You can have with you the entire text of the judgment and then read it. You will find it interesting. It will expand your knowledge, will add clarity to you with regard to this subject. I think I should now proceed to some other test. Nobody is responding. Are you? Can you? Besides this D.N.A., I should now deal with others. Point number, para number 4.2. Para 4.2. Preconditions for the admissibility of scientific evidence. It's a very good judgment of the Supreme Court, and it's by three judgments. 2005 Criminal Law Journal, page 2533. Ranjit Singh, Brahmajit Singh Sarma versus State of Maharashtra. A three judgments of the Supreme Court ruled in the year 2005 in the case of Ranjit Singh, Brahmajit Singh Sarma. If these 6 conditions are fulfilled in relation to a scientific test report, only then that test report can be accepted by courts, not otherwise. Again, pointing out the para 4.2. Preconditions for the admissibility of scientific evidence. Supreme Court says, if these 6 conditions are fulfilled in relation to the report of a scientific test, then report can be accepted by the courts. Number one is, first condition is whether the principle or technique has been or can be reliably tested. The technique, the method which is applied or which has been applied in conducting the test, whether it is universally recognized, it is a scientifically approved method, or some Tom, Dick and Harry is claiming he is of the view that the method which I applied as an expert is okay. No, unless it has been tested and found by the expert to be safe, to be applied as a method for conducting the test, only then the test report would be accepted. Not just because somebody is claiming the method he applied is foolproof, is rational method, logical method. No, it should have been tested, and experts of this field generally agreed that yes, the method which was applied in conducting the test, that was a logical, rational, and scientific method. So this is the first condition. Number two, whether it has been subject to peer review or publication, whether if somebody claimed he had invented a method of conducting a test, his claim should, his methods should have been tested by experts in other part of the country, other parts of the world. And if the scientific community is agreed, scientists world over are agreed, yes, the method invented by Mr. X is a scientific method. A result produced by such scientific method is safe to be accepted on, relied on. Then if this test is fulfilled, this precondition is fulfilled, report can be accepted. Number three, it is known for potential rate of error. You know, many scientific methods are fallible to a certain degree. The possibility of error, possibility of producing a wrong result cannot be ruled out. Even in medical field, what does a doctor do? To the best of his skill, his understanding, he gives us, prescribes medicine, but he cannot claim the medicine will work, will cure 100%. He is just applying his wisdom, his skill, his knowledge in best possible manner, but he cannot claim, he cannot be sure 100%, because chances of error, chances of mistake in diagnosing the case and prescribing the medicine is always there. The same is the position here. The chances of error in the test should also be known. And fourth one is whether there are recognized standards that control of the procedure of implementation of the technique. The procedure should be standard one. It means that the procedure which is applied in conducting the test, it should not be known just to the expert who applied the method, the procedure. It should be known to others as well. The experts community, scientific experts community must be familiar with such procedure that was applied in conducting the test, particular test. And everybody should be agreed, yes, this is a well-known method which has been applied in conducting this particular test. Otherwise, if this method is not universally known, the scientific community, the experts community do not recognize such method, it cannot be said to be a standard method. Then whether it is generally accepted by the community, whether the society, the nation can accept such test, and whether the technique has been introduced or conducted independently of the litigation. If a method has been applied by the expert just for a particular case, and in some other case a different method is being applied, in a third case some third method, in fourth case fourth method, so this is no method at all. Method should be of universal application. It must have received universal recognition. The community of experts are generally agreed, yes, this method is uniformly, universally applied, and it is safe to apply it. So when these 6 preconditions are fulfilled, only then the claim of an expert that he had prepared the report, test report, after applying a particular method can be accepted. Otherwise, if his report, his opinion of the expert does not conform, does not withstand these 6 preconditions, irrespective of the claim of the expert, his report has to be rejected. I think you will have sufficient clarity on this subject if you read this good judgment, Ranjit Singh Brahmajit Singh Sarmaj case of the Supreme Court, which was pronounced by the Supreme Court in 2005 by a bench of the strength of 3 judges. Take you people to narco analysis polygraph beep test not permissible to be conducted on accused. I'm inviting your attention to para 7.2. 7.2. 7.2. That Selvi case, Srimati Selvi, State of Karnataka, 2010 Supreme Court, 3 judgments, wherein DNA was made permissible. In that very case, Supreme Court says, yes, DNA can be conducted without consent of the accused, but other tests like narco analysis, polygraph, beep test, lie detector, they cannot be conducted because, as I had already invited your attention to Article 20, Clause 3, it bars such tests unless the accused gives his consent, because Article 20, Clause 3 provides that an accused cannot be compelled to create evidence against him, to produce evidence against him so that tomorrow he could be convicted. It is the duty, bounden duty of the prosecution to lead its evidence. Burden is of the prosecution to prove that the accused is guilty. Why should accused be compelled to prove that he is guilty? This is what Article 20, Clause 3. So this is Selby's case of 2010 pointed out to you. I am providing 15 minutes more.
Okay, sir.
Questions, only questions. It's a big subject. Article is available on website.
Ji, sir.
To it. Now I will like to entertain their questions.
So there have been recent judgments on interpretation of Section 531 BNSS. Can you shed some light on that?
Yes,
Applicability of the new law. Yes, sir.
Right. Why not? Why not? So then I am closing this subject and taking you to new criminal laws. There is a subject of mine on this website. New criminal laws. Ask the participants to open it. There has been a very important case from the Allahabad High Court on August 6th this year, 2024. 6th August 2024. It's a very beautiful judgment. It's available under the caption criminal laws. Everybody must be having his mobile or laptop with him. Ask him or her to open the website lawhelpline.in. Then in red caption, there is criminal laws. It contains, criminal laws heading contains 38 files. Open the last file, 30 at number 38. New criminal laws. New criminal laws. New criminal laws means Bharatiya Nyaya Sanhita 2023 IPC. Bharatiya Nagrik Suraksha Sanhita 2023 means CRPC. Bharatiya Sakshya Adhiniyam 2023 means Evidence Act. The point is here, what is the position of applicability of CRPC and BNSS? Whether CRPC has completely gone out from courts, from police proceedings, or it is still relevant? Then the answer is yes, it is still relevant. The position of law is that CRPC is very much in use even after July 1st, 2024. You know, all these new criminal laws have been made applicable, have been made put in force from 1st July 2024. So a question arises whether CRPC is no more relevant. It is not in application. No, answer is yes. CRPC is equally in application. Rather, in comparison to BNSS, these 3 criminal laws apply and apply vigorously. Where this CRPC applies and where BNSS applies. Please come to para 4.2 of my write-up, New Criminal Laws. Para 4.2, it is available on website. If you can open it, if there is any screen whereon you can project it to show your participants. Para 4.2, Summary of Division Bench Judgment dated 6/8/2024 of Allahabad High Court on applicability of IPC, BNS and CRPC and BNSS. I am reading out. Summary of Division Bench Judgment dated August 6 of Allahabad High Court is like this. Roman 1, 2, 3, 4, 5, 6. It is in 6 parts. If you have opened, please read where CRPC will apply and where BNSS will apply. The point at point Roman 1, Allahabad High Court has clarified if an FIR is registered on or after 1st July for the offence committed prior to 1/7/2024, then the FIR would be registered under the provisions of the IPC. Means that those offences which were committed by an accused by June 30th, the FIR would be registered for the penal sections of the IPC. Why it is so? If penal law does not apply retrospectively, an accused can be punished. He can be given only that punishment which was in force when he committed the offence. So it is the date of offence that is relevant for purposes of awarding the penalty. Suppose कि just take an example कि for the offence of theft, a theft committed up to June 30, 2024. Suppose the penalty was for 1 year's imprisonment. And from July 1, this penalty for theft became 3 years. And a person had committed the theft on June 30 or before that June 30. So he cannot be awarded 3 years imprisonment because 3 years imprisonment came to be in force from July 1. But when he committed the offence of theft on June 30, the penalty was only for 1 year. So this changed, enhanced penalty would not be applied, would not be awarded against him because it is the date of offence which is relevant for purposes of awarding the quantum of penalty. So this is what this division bench Allahabad High Court is saying. Please read it carefully. If an FIR is registered on or after July 1st, 2024 for the offence committed prior to July 1st, then the FIR would be registered under the provisions of the IPC. But the investigation will be conducted as per the BNSS. Section 531 of the CRPC, or not CRPC, BNSS. Section 531 of the BNSS 2023 makes this clear. A word occurs pending. Pending word occurs in section 531. If investigation was pending on July 1st, it would be conducted under the CRPC. It means the investigation had started under the CRPC. So a proceeding which had already started or which was already pending under the provisions of the CRPC, then from July 1, when new law came into force, that old law will continue to apply. But if the investigation could not start by June 30th, it started on after July 1st, then this new law will apply. Read it carefully, it's very, very typical. But this is the absolutely correct position of law which Allahabad High Court, its division bench, has clarified on August 6th. So if an FIR is registered on or after July 1st for the offence committed prior to July 1st, then the FIR would be registered under the provisions of the IPC, but investigation would be conducted under BNSS. Come to point number 2. In the pending investigation on July 1st, investigation will continue as per the CRPC, and all other proceedings would also be taken by the court as per the CRPC. Then Roman 3, the cognizance on the pending investigation on or after July 1st would be taken as per the BNSS, and all the subsequent proceedings, including inquiry, trial, or appeal, would be conducted as per the procedure of the BNSS. Then come to Roman 4. Section 531, subsection 2, clause A of the BNSS saved only pending investigation, trial, appeal, application, and inquiry. Therefore, if any trial, appeal, revision, or appeal, if any trial, appeal, revision or application is commenced after July 1st, the same will be proceeded as per the procedure of the BNSS. So is this Roman 4, Roman. You must have clarity when CRPC will be applied and when BNSS will be applied. Simply because new procedural code, the BNSS, has come into force from July 1, 2024. It doesn't mean the CRPC is altogether gone. No, in pending cases, as per the guideline of the Allahabad High Court, and as also provided in section 531 of the BNSS, this is the scheme of applicability of the CRPC and the BNSS, has been clarified by the Allahabad High Court Division Bench in its judgment dated August 6, 2024, passed in Deepu versus State of Uttar Pradesh, DEEPU, Deepu versus State of Uttar Pradesh, para 16 of judgment dated August 6, 2024 in Deepu case clarifies when CRPC will apply and when BNSS will apply. So I would request you people read it twice, thrice, or as many times, so long as you understand it. And whenever a question arises, whether your application, your petition should be moved under the new provisions, under the new section in the BNSS, or under the CRPC, or a particular proceeding should be undertaken by the court under the old provisions of the CRPC or under the new provisions of the BNSS, you must consult this judgment. Otherwise, there is confusion, there is some sort of absence of clarity. Different people interpret the provisions of section 531 of the BNSS in their manner, in the manner that suits to them, but that's not the correct legal view. Correct legal view is this, which the Allahabad High Court Division Bench ruled in its judgment dated August 6, passed in Deepu versus State of UP. And
Okay,
you know,
sir.
criminal law, this new criminal law is now in the process of evolution. The Court of Records, which means the Supreme Court and the different high courts, they are now engaging their attention, interpreting the provisions of the BNSS, the Bharatiya Samhita, the Bharatiya Sakshya Adhiniyam. In fact, there is no major change in the Bharatiya Sakshya Adhiniyam. All the provisions of the Indian Evidence Act 1872 have been adopted in this Bharatiya Sakshya Adhiniyam. The focus is, emphasis is on scientific evidence. As regards IPC, for which we now have Bharatiya Samhita 2023, certain new offences have been added, but majority of the penal provisions are the same, which were already there in the IPC. The same is the position here about this CRPC and this BNSS. Maximum procedure that was already there in the CRPC has been adopted mutatis mutandis in this BNSS. There are only few sections, few places where a new procedure has been added, or the pre-existing procedure of the CRPC has been partly or fully amended, substituted, replaced. If you go through this article of mine, you will find sufficient clarity. They have not come prepared, therefore they lack questions. Always enjoy asking questions, seeking
Yes, sir.
clarity.
Bindra sir, Virendra sir.
Yeah, a very good afternoon to you, sir. As usual, your lectures are truly enlightening. So just one question, as defense, if you need certain, investigations required, where the defense does not have access, for example, you want CDRs or you want some IP addresses, etc., etc. Is that something that the defense can request the police to conduct on their behalf and helping the case of the defense?
Again, articulate your question.
Yes. So, sir, if the defense requires certain investigations, okay. So, for example, the defense will not have access to any specific forensic analysis, or they might not have access to certain IP addresses, or if they need some call records. Can they
Not
request
your,
the police to conduct on their behalf?
no, not at all. Investigation of crime is the prerogative of the investigating officer or the investigating agency.
Right.
And an accused person cannot set the mode and manner of investigation.
Okay.
The state have no power to direct the investigating agency or investigating officer to conduct the investigation in a particular mode or manner. Quite plenary powers have been given to the police, to the investigating to conduct the investigation in the manner prescribed in law. So this procedural code, earlier CRPC and now this BNSS, they heavily tilt in favor of the investigating agency.
Correct. That's what my fear is. So, sir, if I need some call,
yeah. To say the most unfortunate, unhappy, the police should be given
unbiased,
so much vast freedom to conduct investigation as they like to conduct. Just take one example, recording of statement of a witness under section 161 or 164. These are alternate options available with the police. If the investigating officer thinks it proper, he can take the witness to the magistrate for recording his statement under 164. And right. if the police officer says no, he will not take the witness to the magistrate for recording his statement under 164, matter ends here. Even the court, magistrate is helpless, session judge is helpless, even High Court, Supreme Court are helpless. Supreme Court, in exercise of its power under 142 of the Constitution, they can issue a direction. Rest, everybody is here. So how this vast unfettered power has been given to the police? Suppose the statement of the witness has not been properly recorded by the IO under one. It's not proper to say ki how the statements are recorded by the investigating agencies under 161. Many a times people complain that even the witness was not contacted by the IO. He recorded the of the witness while sitting at the police station itself. In the manner the IO lied, certain statements were recorded which the witness has never told to the IO under 161. But these crucial legal issues have not been addressed in the BNSS.
Very unfortunate, sir.
We are gone on a different footing while discussing these issues. My role is to keep myself confined to the provisions contained in the BNSS. But if you wish me to find fault with the provisions, existing provisions, so then I'm not much satisfied with the main malady, the main issues which affected the investigations.
Right.
They have been left unaddressed, unnoticed.
Right.
So then claiming that we are living in an era where we are having fantastic, wonderful criminal laws now is something like blissful thinking. But being a student of law, I will again revert myself back and will keep myself confined to the existing provisions. Otherwise, it may amount to questioning the wisdom of the legislature, and the Supreme Court has again and again ruled that the legislative intent cannot be questioned. Legislation of laws, enactment of laws is the function of the legislature.
Right.
It was for the legislature, for the parliament to enact laws in the manner it liked. Right. So legislative wisdom, their prudence, their skill, their understanding cannot be questioned. Therefore, I will bow my head to the legislature and will abide by the provisions enacted. Whatever they are there, it has to be obeyed, it has to be respected. But there are serious lacunas.
But sir, thank you
Justice
so much for your frankness.
Had there been really a justice-oriented approach on the part of the draftsmen at the drafting committee, they would have, I think, must have addressed such issues. In my Stacy, several decades experience in judiciary and as a trainer and teacher for the judges magistrates, I can say the basic issues which affect the justice, they are hopelessly left
Ignored.
unaddressed, unremedied.
Thank you, sir. Thank you sir, very much, sir. You have addressed from different perspectives, and thank you so much for your transparency, sir.
वीरेंद्र सर।
हम भी थक गए, 2 घंटा हो गया।
जी सर।
चलो नेक्स्ट जब कुछ रखना तो बताना।
सर एक लास्ट क्वेश्चन ले ले। सॉरी
हाँ,
सर।
Am I audible?
क्यों
हाँ।
नहीं?
Am I audible, sir?
Yes, yes.
Yes. Sir, just one question. In a particular case, FIR was filed in 2021. Charge has been filed, and cognizance has been taken by the magistrate in February 2023. But framing of charges is not yet done. So, will the trial go as per CRPC or because there is one judgment of Supreme Court that Article 20, Clause 1 of the Constitution says that an accused person has right only over the substantive law, not over the procedural law. So an accused person cannot insist on a particular procedure being followed. So new procedure can apply even in case of offences registered under the old substantive laws. So in this case, since the charge sheet has been filed, but the trial framing of charges has not yet done, so will BNSS apply or will say CRPC apply? That is the question, sir. Thank you.
You must read Deepu versus State of UP.
Ji, sir.
Pointed out Deepu versus DEEPU. Deepu versus State of UP.
Okay, sir.
Court Division Bench. Judgment dated 6 August 2024.
Okay, sir.
This is Division Bench judgment. If you want to note down writ petition number, then criminal miscellaneous writ petition number. Criminal miscellaneous writ petition number.
Yes.
12287.
Okay. 12287.
2024 Deepu State of UP Para 16. It's a lengthy judgment. Note down.
Okay,
para,
sir. ठीक है.
Para 16.
जी, sir.
I was just pointing out.
Okay.
It says.
Yes.
As regards the issue of applicability of substantive law, penal law, and procedural law.
Okay.
Hello. Wherein it has been ruled for that in the matter of procedure, no party can claim for the time being the procedure there. Procedure to all the penalties unless the amended act otherwise provides. Here in your amended new legislation, this BNSS, its section 31 is relevant here. Section
531. Yes.
Clearly provides when
pending what is there. Yes.
Section 531 of the BNSS uses a particular pending. It says where this point number 1 of Roman 1 of para 16 of this judgment is relevant. I am again reading it. If an FIR is registered on or after July 1st for the offence committed prior to July 1st, then the FIR would be registered under the provisions of the IPC, but the investigation will be conducted as per the BNSS. Try to understand this phase of the judgment. If the investigation was already, if the investigation had already been started by June 30th, then the investigation would be conducted, investigation would continue to be conducted as per the CRPC. But if only FIR was registered by June 30 and investigation had not commenced, so then from July 1, BNSS will apply. Investigation will be conducted as per the procedure in BNSS. Again repeating, if the investigation had started by June 30, then CRPC will apply. And if the investigation had not started by June 30, then from July 1, CRPC cannot be applied for investigation. This new law will apply because word pending. If the by June 30th investigation would have been started, it means कि on July 1st investigation was already pending under CRPC. So then investigation will continue as per CRPC. But if only FIR was registered by June 30th, and investigation for the first time is going to start from July 1, so then only BNSS will apply. Read this judgment very carefully. It's quite clear. It makes nothing unclear. Everything is doubt clear for all the circumstances, in all the conditions. So this is a very good judgment. Otherwise, there was a lot of confusion, a lot of ambiguity, vagueness. Every people in lower judiciary, in the High Court, even in Allahabad High Court, other High Court, had just their subjective ideas, their interpretations. But with this judgment from Allahabad High Court from August 6, applicability of CRPC and BNSS is quite clear.
Okay,
should I-
thank you so much, sir.
Thank you.